Nicole for putting on this meeting today. We're happy to see so many people here with us. Before we get to the main event, I have several announcements that I need to make. First of all, there's a heritage team at corporate, and they, along with B-Link, have arranged for retirees to take a tour of the relatively new Good Neighbor Museum. Information for signing up for that tour is available on the goldtimers.org website. All the details are there, but I wanted to share a couple of them with you. There will be multiple tours on Friday, September 23rd, and Monday, September 26th. Pre-registration is required. You may bring a guest. It's important that you enter the birth date for yourself and your guest in the comments field, because since it is at corporate, we'll be going through security, so bring your driver's license with you too, please. There will be time at the conclusion of the tour to visit the company store, as well as to play with some of the interactive displays that they have in the museum. My next announcement applies to all of us, even if you are not yet 65, okay? The Senior Health Insurance Program, which is also known as SHIP, is helpful for those people who are new to Medicare or anyone trying to navigate the system and meet deadlines or just wants to evaluate whether or not you make the right choices when you're signing up in the next enrollment period. SHIP counselors are trained, certified, and experienced in offering one-on-one information for all aspects of Medicare. The service provided by the SHIP counselors is free, and they are not affiliated within the insurance companies, so basically they're not trying to sell you anything. So it's really a good service they provide. Let's see. The annual open enrollment window is October 15th through December 7th. And they are encouraging all current Medicare enrollees to review your Part D coverage. They have some statistics that say that about half of all the reviews that they help with, there are cheaper Part D plans available, so you want to take a look at that every year because the companies change their prices, their formularies, and plus, as your health changes, your prescription needs to change. They have two gentlemen who happen to be State Farm retirees sitting out in the hallway today. They are both trained SHIP counselors. Their phone number is listed on the brochures that they have, as well as on a little sign they have. I'm going to give it to you here as well. It's the ARC phone number in normal. It's 309-888-9099. So again, that's 309-888-9099. So the Jim and Ralph are the two counselors, and they are intending to stay after the meeting, so if you've got any questions, you can talk to them. My next announcement has to do with travel. There's a lot of brochures at the direct travel table. One of them is this one. It's got all the different trips in there. And on the first page is a list of informational meetings. And those informational meetings will have Laura Carlson from Colette Travel there, and she's going to explain what the trip is about, give you some of the highlights that you're going to see, and answer any questions. So if you are interested in considering any of those trips, that would be a good opportunity to learn. There's also an informational meeting scheduled for a trip to Egypt. And the current Egypt trip is rather expensive, but they have other opportunities for less expensive trips. And part of the reason the one trip, the cost includes a lot of special add-ons with it, so you might want to check that meeting out too. At this point, I'm going to turn the microphone over to Brett Peterson. He is one of our sponsors. He's from Busey Bank. And we had a slight change in plans due to COVID. Brett is going to assume Joe Hack's role today, as well as his role as sponsor.
I know we're all disappointed with that. Again, thank you for having us today. Again, my name is Brett Peterson. I lead the wealth management team for Busey here locally. I know there's a lot of familiar faces in the room, but for those of you who I haven't met, it's good to see you. Today's presentation, when we're putting it together, what's nice is that obviously the local attorneys and all of their experiences are similar, but they're different. And so again, when I look at this or when we were reviewing this, there's a lot of practical and useful information inside this presentation. So again, Chad, John, and Nicole, thank you for coming. Really appreciate that. Appreciate that there. So we give a round of applause. Don't think I appreciate that. And just again, just a few updates from us on the UC side. So we've been hosting in-person workshops. So I think we've hosted 3 or 4 of these at this point, right, Leanne? And we had one recently around the tax update that went really well. We're going to host another one in October. So these are in-person events hosted at UC. This one's going to be around the investments, the market outlook, the current conditions going into the new year. Again, we're going to have a more formal presentation for the larger group in November here at the Chateau, but we are going to hold another in-person workshop in October. And that information can be found at the Gold Timers website. Before I kick it over to the attorneys and let them kind of go through their presentation, I do want to introduce my team. I have Taylor Morgan here with us today, Catherine Wills, Emily Leeds, Matt Lage, Jessica Cruz, and they are very helpful in getting all these things organized. Again, the Gold Timers group as a whole does an amazing job organizing the events, especially over the last couple of years with COVID. But again, just a big thank you to my group and all the work they do to kind of get this organized. So with that, I'll let, who's first? Chad? Okay. I'll let Chad take it from there.
All right, I got a little mic on. Can everyone hear me with the mic the way it is? Okay. So I'd like to introduce you to our presentation, Estate Planning and Pitfalls. And again, it's a 3-attorney panel. We all are estate planning attorneys. Nicole is in-house attorney for Busey Bank, but she does do your trust in the trust department and so forth. So with that being said, we'll introduce ourselves. I'll do an overview of what we're going to cover today, and then each of us has specific sections that we're going to address, but then there's going to be some discussions at various points on certain topics. So, and then at the beginning we have a Q&A session. There were some questions submitted before when people registered, so we'll address those, and then any questions you guys have in the audience today. So, with that being said, we'll see if this clicker works here. I'll turn it over to Nicole.
Okay, good morning everyone. I'm happy to be here with all of you. As Chad mentioned, I am an attorney at Busey Bank. I began my practice in St. Louis doing estate planning at a couple of different law firms, doing plans for high net worth families and individuals. And after a number of years, I switched to working at banks. So I worked at a couple larger banks and at Busey. My role at Busey is I'm responsible for handling fiduciary legal compliance, governance, and risk matters for Busey Wealth Management. So I consider Brett and his team part of my internal client group. So part of my role is to review folks' estate plans, talk with them about some different ideas that they might be considering, or we'll partner with their own attorneys as they're getting the documents drafted. So happy to be here with these two fellows and hear any questions you may have.
Good morning, everyone. Thank you very much for having me. My name is John Pratt. I'm an attorney here in Bloomington with the law firm of Pratt and Pratt. Recently, I woke up to the idea that I've been practicing here for over 30 years. It was a little scary, but it's been good. I love being here. I'm a graduate of Bloomington Public Schools. I'm also a graduate from the University of Kentucky and the University of Illinois Law School. And I am the brother-in-law of Greg Merle. And so I always like to tell State Farm retirees that I have, in fact, changed the diapers of the great-great-grandchildren of GJ.
Well, I have to follow that. I really, yeah. My name's Chad Ritchie. I'm from McLean County, grew up in Colfax, Illinois. I grew up on a farm about 4 miles south of Colfax. I went to Illinois Wesleyan University for my undergraduate in Southern Illinois School of Law for my law degree. I've always practiced here in Bloomington and McLean County. I've been an attorney, it'll be 20 years this November. And probably the last 9 years, I've really focused and concentrated on estate planning. So estate planning is all I do, estate planning and estate administration. I've got 2 kids. Well, my oldest daughter just went to college. Her name is Addison. Jackson is 15. He goes to Tri-Valley School here in this area. And then my wife, we've been married 24 years. She also is from Colfax. She's a nurse here in town. So anyway, with that being said, I want to give a little disclaimer. Even though we're talking about estate planning, we're giving a lot of general information about estate planning. This is not legal advice. Of course, we have a little fine print with the attorneys up here. So it's for informational purposes only. We encourage you to use your own attorneys to talk about your various estate planning issues based on what we've talked about today. And there is no attorney-client relationship based on what we've talked about today with you guys. So just getting that out of the way. As far as what we're going to talk about today, first, John's going to give an overview of power of attorney documents. These are documents that you sign where you name agents for people to take over for banking and property and healthcare-related decisions. John's going to talk about that. And then the rest of the presentation will be more about what happens to your assets and how we're going to plan for your assets when someone passes away. And so we have some, what I call the estate planning key concepts that we're going to go over. And I think it's really helpful for people to understand these key estate planning concepts that we can build on when we talk about estate planning in general. The main key concept I like to talk about is probate versus non-probate assets. And so all the assets that you guys have can be categorized between a probate asset and a non-probate asset. Once you understand that, then everything, I think, becomes a lot simpler when it comes to estate planning. We're going to talk about will-based plans and what they do and what they don't do. We're going to talk about trust estate plans, what they do and what they don't do. And then we're going to talk about, well, should you have a will-based plan or a trust-based plan, and the pros and cons of each. And so I know when I talk with my clients, I'm sure when John talks with his clients and so forth, that's one of the first questions that we want to answer when you get your estate plan done, is do you need a will-based plan or a trust-based plan? They're basically 2 of those categories to start with. So then John will talk about estate tax overview, estate taxes, just kind of touch upon that. And then we have our estate planning words of wisdom. Notice those are in quotes. So we'll all talk about some things that we see on a daily basis when we practice that we think would be helpful words of advice for everybody in the room, and then our Q&A, and then we'll wrap things up. So with that being said, I'll turn the stage over to John, and he'll talk about the power of attorney documents.
Thanks, Chad. I want to thank Chad for really organizing our slideshow. Appreciate it, Chad.
Sure.
So I'm going to talk about powers of attorney, and my honorary younger brother, Eric, might say something like this. Powers of attorney are the most boringest subject, but sorry about that. They are very important, and we all agree we should spend a few minutes on that topic. Most of today's presentation is going to be on planning for how to distribute your assets after you die. And that's what most of our discussion will be on today. But powers of attorney impact you while you're living. These are documents that are used by your loved ones to take care of you if you become incompetent. So they're very important. We can always figure out what to do with your stuff after you're gone, if you don't have an estate plan. But if you become incompetent without this power of attorney, it's going to be a burden on your family, and it's going to be, and you're probably not going to get the type of care you deserve. Okay, power of attorney is simply a statutory document. These documents come from the Illinois statute. They're written documents that are signed, and they appoint an agent for you to make decisions for you. I like these powers of attorney to be effective immediately. That seems weird because you really don't want the agent to start working until after you're incompetent. But if they're effective immediately, then the agent doesn't have to prove why you're not able to act. You don't have to have doctor's visits, you don't have to notes from doctors, you don't have to go to court or anything like that. The agent is there ready and able to act for you. We have two forms of powers of attorney in Illinois. They should be separate. You don't want joint forms, you want two separate forms. One is a power of attorney for property, and one is a power of attorney for health care. Again, the power of attorney for property assigns an agent to make decisions for you, and you can have successor agents. Now, a lot of you are thinking, well, I have joint accounts with my spouse or with my kids. Why do I need a power of attorney? They can already write checks for me. Well, typically everybody has unique accounts that are uniquely theirs, like IRAs, 401ks, other retirement accounts that are uniquely yours. There are no joint owners on those accounts. And if you don't have a power of attorney that's able to make investment decisions for you or withdrawal decisions for you, it's going to be difficult, again, for those that you leave behind. Also, deeds. If you own real estate with someone, then you have to sign the deed. And obviously, if you're incompetent, you're going to need your agent under a power of attorney to sign a deed for you. If you don't have a power of attorney, what we normally do is do a guardianship. And that's about a $5,000 to $10,000 endeavor involving a couple different attorneys. And it's, like I said, it's costly and it's demeaning. We have to take you in front of a judge and say why you can't make your own decisions. And oftentimes, it splits the family. The family starts to get in a fight as to who is going to be the guardian. Healthcare power of attorney, it's the same concept. You're able to appoint an agent that can make healthcare decisions for you, including access to your medical records and making appointments for you. The other thing about the healthcare power of attorney, this document comes right out of the statute and it has an advance directive. That's the legal phrase for deciding in advance how you want to be treated under certain circumstances. What I'm talking about right now is artificial hydration and nutrition. If you don't want to be stuck on the machine, if you want to quote unquote unplug from the machine, you need to have one of these healthcare powers of attorney, and it gives the authority to the agent to make that decision for you. Again, if you don't have a healthcare power of attorney, it's going to be very, very difficult to get these decisions done for you. In the healthcare environment is spouses don't have all the rights that you might think they would to make decisions. Children certainly don't. Siblings don't. So you almost have to have this healthcare power of attorney to do things such as the advance directive. Obviously, powers of attorney need to be done while you're competent. You can't wait until after you become incompetent. That you can't do it then. You got to get them done before something happens. And then one little word, just a little advice. Don't rely on those powers of attorney that the hospitals hand out. Like I said earlier, I've been doing this a lot of years, and I've probably seen 30 or 40 forms that the hospitals hand out, and some of them don't look like the statutory form at all. And of course, we want the documents to look like the statutory form so that if anybody questions them, then we know we have the authority to do what the healthcare power of attorney says. There's one form in particular that has a list of 30 or 40 yes/no questions, if this, then that. That form is not a power of attorney, I can assure you of that. So check your forms, make sure you have the right forms, and make sure you have powers of attorney in place. All right, thank you.
All right, thank you, John. So our next topic is our estate planning key concepts. And I failed to mention this before, but you do have our slides so you can follow along if you can't see the screen very well, if you want to take notes. There are some of the transition slides I have are repetitive, so I did not include those in the handout, but all the main slides are in there. Plus, there are a few key diagrams that I'm going to be covering today. You've got a full page copy of those, so you can refer to those, take notes, etc. as well. So, let's get started with estate planning key concepts. I always find it's helpful if we have a little case study or a hypothetical scenario that we can follow along as we go through and learn about these things. And my case study are the Smiths, the Smith family. And there you can see the Smith family. We've got John and Jane Smith there in the middle. They're the mom and dad. They're in their 70s, and they have 2 adult children, Tom and Sally. And so Tom and Sally are in their 40s. We don't go much into the details of the family or anything, but we just want to kind of set the stage. We want to go through some assets of John's and see what happens to those assets when he passes away, depending on what kind of plan he has. And so for our first hypothetical, John and Jane don't have a will, trust, or any power of attorney, so no estate planning in place. What's going to happen to John's assets when he passes away if he doesn't have a will? So we have here, and this is one of your slides, the assets of John Smith. And again, this is more of a simple scenario. We don't have any of Jane's assets potentially on here that she has on her own. We don't have life insurance and some other stuff like that too. But I want to show you the asset, the value, and how it's titled, or if there's a beneficiary on there. And so when you think about your estate plan, this is something that you're going to want to think about. Something I always go over with my clients is what kind of assets do you have, and do they have beneficiary designations, or are they jointly owned? Because that makes a big difference on how things get transferred when someone passes away. So, for example, John has a house worth $250,000. He owns that jointly with his wife, Jane. He has a duplex, whether it's a rental or a vacation home, doesn't matter for our purposes, but it's some real estate that he owns just in his name. It's not jointly owned with his wife. He's got a savings account just in his name, 2 CDs with Tom and Sally as beneficiaries, a 401k with Jane as beneficiary, and a car just in his name, and some household items that he owns with his wife, Jane. Total value of his estate is $1.265 million. So, with that being said, we kind of set the stage here. We want to talk about what are probate assets and what are non-probate assets. And so, to answer that question, we have to know what is probate. So most people have heard of the term probate. You might have had to go through that process with parents or some family members of yours if you've gone through the official court probate when they've passed. But probate is a court process of transferring legal title to property from a person who has died to that person's heirs or legatees. And so there's some key words there. One, it is a court process. We have to actually file paperwork with the court and go in front of a judge and have a judge sign off on things. 2, the main thing for probate is it transfers legal title to probate assets, which we'll talk about in a minute. And we're transferring those to your heirs or legatees. If someone has a will, the people you name in your will that inherit through your will, they're called legatees. And if you don't have a will, then we look at Illinois law to see who's going to inherit your assets. Those people are called your heirs. So it's either your heirs at law or legatees. Okay, so now with that being said, what is a probate asset and what is a non-probate asset? Probate assets are assets that are 1, owned in one person's name, and 2, do not have beneficiary designations. So these assets do not automatically transfer when someone passes away. So think about that bank account that John Smith has just in his name with no beneficiary designations. That is what we would call a probate asset. When he passes away, that asset does not automatically or easily transfer upon his passing. That may have to go through the court process of probate. Now, what are non-probate assets? These are assets that are owned jointly with right of survivorship. So John and Jane, anything John and Jane owns together jointly will be considered non-probate assets. Anything that has a beneficiary designation or anything that's in a trust. So those things will easily or automatically transfer upon someone's passing. So in order to kind of figure out what happens to John's estate, we have to identify what assets are his probate assets versus his non-probate assets. And so you say a picture's worth 1,000 words, and this is one of the big slides that you guys have printed out too. So you can see on the non-probate asset side, things that have beneficiary designations. So you can think about this from your own estate, your own assets. If you have life insurance, you should have beneficiaries named for those life insurance policies. And I recommend you have primary beneficiaries and secondary beneficiaries. Just in case that primary person passes away, and then you've got someone to inherit as a secondary beneficiary. Retirement accounts have beneficiary designations. Bank accounts can have beneficiary designations. We call those POD, or payable on death accounts. A lot of people don't realize you can name beneficiaries for checking accounts, or CDs, and that sort of thing. So that's something you could do as part of the estate planning process. Brokerage accounts, same concept, naming beneficiary designations for brokerage accounts. We call those transfer on death accounts. Illinois allows you to name beneficiaries for your real estate if you want to. Again, that's where you would want to talk to an attorney whether it would be a good idea or not. But a TODI, a transfer on death instrument, it is a deed-like document that says who inherits your house or your real estate upon you and your spouse's passing, if both of you own it. So it will guarantee your house does not go through probate. And finally, anything jointly owned or held in a trust are non-probate assets. So these are the assets that easily or automatically transfer upon someone passing. Most importantly, they do not go through probate. So then we have the probate asset side. Again, assets that are owned just in one person's name, not jointly owned with anyone else, and do not have beneficiary designations. Those are probate assets. Your will or Illinois law will say who inherits those assets. And then, I'm not going to go through all the probate process stuff, but you can see here when John dies, step 1, all the way through step 12, final distribution of his estate. That takes about a year if there's no complications with his estate, or it could take many years if there are disputes and that sort of thing. So because it takes a long time to get through probate, because it's expensive and you're paying attorneys and so forth, most people want to avoid probate for their estate if they can. And I think Nicole's going to talk about some reasons maybe why you would want to go through probate in a little bit. And then there's finally a small estate affidavit in Illinois where if your estate qualifies, if you've got less than $100,000 of probate assets, your estate, you can transfer those assets without having to go through probate. So just as a little overview, small estate affidavit, an affidavit that banks, financial institutions, and other parties holding estate assets can rely on, so probate assets can be transferred without having to go through probate. Basically, Illinois passed a law many years ago that said, hey, we don't want to clog our courts up with what we deem as small estates, so we're going to have the shortcut available to people. And so if your estate, probate asset-wise, is less than $100,000, then you don't have to go through that court process. Someone can sign an affidavit and tell the bank who inherits these assets, or the DMV for cars and that sort of thing. So that's what we're kind of looking for, is we're going to try to see, does your estate have less than $100,000 of probate assets, or is it more than $100,000? And then we can kind of evaluate from there. Okay, so that's just, again, saying we want your estate would have to be under $100,000 for the small estate affidavit to apply. So let's look at John Smith's estate. Let's look at his assets. And so if we look at his assets and we evaluate how those are titled and if they have beneficiary designations, we can categorize these assets as probate or non-probate. So based on that evaluation, we can see the duplex, just in John's name, no beneficiary designation. The savings account, just in John's name, no beneficiary designation. And the car, just in John's name, no beneficiary designation. These are probate assets. So if we recategorize these assets, then we've got the probate assets listed worth $370,000, and the non-probate assets listed $895,000. So that tells us a lot of information about John's estate and what we may need to do for estate planning purposes. So again, with John's estate, remember he did not have a will, so we're looking at Illinois law, and we have $370,000 in the probate asset category. So we have to look at Illinois law to see how those assets are going to be transferred, who they go to. Those non-probate assets over there are going to be controlled by beneficiary designations and whoever the joint owner is. So what happens to John's estate when he dies with no estate planning, no will or trust? We're talking about the Illinois estate plan. Now, I have a few jokes about the Illinois estate plan, but I will not go there today. So Illinois estate plan. This is kind of the basics. This is what Illinois says what happens to your estate if you have no estate planning in place. One, if you have a spouse but no children, everything would go to your spouse. If you have children but no spouse, everything goes to your children in equal shares. So I think most people would probably agree with those types of those distributions. Here's where things start to go bad with the Illinois estate plan. If you are married and have children, then one half of your estate will go to your spouse, the other half will go to your children in equal shares. So you can think of all the different scenarios that may occur. What if John was a business owner? Half the business is now the kids, half is the James, and so forth. There's lots of different scenarios. What if their kid was an infant? Now that child is going to have half of his probate assets and so forth. Probably not what John would have wanted. And it kind of goes from there. After that, I won't go into all those details. But basically, we've got John Smith's estate again, the probate and non-probate. How is that going to be divvied up now? Jane is going to inherit the house, the 401k, and the household items because she was either a beneficiary or a joint owner. So she will inherit those as non-probate assets. She will get one half of the probate assets, which is the duplex, the savings account, and the car, because that is controlled by Illinois law because John didn't have a will. Tom and Sally, they're going to get the CDs because they were beneficiaries, but they're going to split the other probate assets 1/4 each. So and the question is, well, because of no estate plan, half of John's estate went to Tom and Sally, the other half would go to Jane. Do you think that's what John would have wanted? The answer, probably not. So then the other question is, well, could a small estate affidavit be used to transfer those probate assets from John's estate? I don't know if anybody has any answer to that. But the answer to that is no, because we have to have an estate probate asset less than $100,000 to avoid probate. So that's our kind of basic analysis of how estate planning works. So with that being said, let's talk about wills. So now you know the difference between probate and non-probate assets. So a will is a document that is signed in front of two witnesses, that's an Illinois rule, that says who inherits your probate assets. So again, that's a key concept. Your will only controls probate assets, not the non-probate assets. So again, we've got your will. You can see that's on the probate asset side. An executor, now every will will name an executor, and so I see a lot of confusion on people, what does an executor actually do? An executor is a person appointed by a court that is responsible for managing the probate assets of a person's estate during the court probate process. And so I have a picture here. You can see in our probate process box, I put executor there in big letters. Your executor is only officially appointed if your estate has to go through that court process of probate. Otherwise, your executor does not officially exist. So the court looks at your will and says, who do you want as the executor? And they will officially appoint your executor. If your estate avoids probate, then there is no executor. Okay. What happens to John's assets upon his death with a will-based plan? And let's assume he puts in his will everything to his spouse if no surviving children, or if no surviving spouse, to his children in equal shares. So again, we look at our probate and non-probate assets. Those probate assets are still $370,000. We're looking at his will now, that he has a will. And we've divided those up again. So now Jane is getting the duplex, the savings, and the car, because the will says that's where she's going. But notice, these are still probate assets. A will only says where your probate assets go. They do not magically make probate go away. So that's another big concept that a lot of people don't realize too. So, 2 key points. A will only controls your probate assets. If you have beneficiary designations, trump whatever your will says. Joint ownership trumps whatever your will says. A will does not make your estate avoid probate. I mentioned that before. So just because you have a signed will does not make sure your estate avoids probate. So a lot of people think that. Okay, trust basics. I'm going to go through some basics and then Nicole will take over with some more details here. Trust. What is a trust? This is my very layman's term definition of what a trust is. It is a bucket that can hold title to assets for the benefit of one or more people. So that's really kind of an easy way to think about trusts. In our scenario, anything that's held that a trust, any assets that is owned by a trust is a non-probate asset. So that's kind of the gist of this slide right here. The Smiths do not have a trust-based plan, so there's no assets in the trust, obviously there. But let's say what happens to it if he did have a trust. Okay, we've got our probate assets here. Let's just, so you can see it's John's name. Now we have a trust and we've transferred it to John's trust. So now we've got those $370,000 in that trust. Now we're on the non-probate side of things. And now, if the trust says everything goes to Jane, if she survives him, she gets the duplex card, savings account, and those assets are now non-probate assets. Now, John could have just put beneficiary designations on the savings account and maybe done a TODI, the transfer and death instrument, for the duplex and not needed the trust. But there are pros and cons with having a trust that we'll be talking about. Trust-based estate plan, assets held in a trust are non-probate assets. That's the key concept. I keep repeating that. The key concept here too with trust, there is much more flexibility and control with a trust. With a will-based plan or beneficiary designations, you're basically saying these assets are going to just be transferred to whoever I say is beneficiary, whoever I name in my will. But then they get that asset outright and they can do whatever they want to with it. So there's no control after you pass away once those are transferred, whereas there's lots more flexibility with how things are set up with a trust after someone passes away. Okay, so then a little bit more here. This is the last diagram I have. This is my three-phase trust diagram. You guys have a bigger copy of this. So, phase one, let's say John sets up a trust. That's basically, a trust is an agreement. It's a document that says where he wants his assets that are in this trust, where they want to go, and how they're distributed, and etc. And so he signs that trust document. Once he signs that trust document, the trust then exists. Once the trust exists, then you can see these little arrows: bank account, investments, real estate, tangible personal property. He's going to need to transfer his assets into the trust, into the name of the trust. So now those assets will become non-probate and they will be part of the trust and not technically part of John's estate. During phase one, we're setting up this trust so that it is a revocable trust. Trusts can come in two major categories. Revocable, which means John always has the ability to amend or even revoke this trust whenever he wants to, while he's living and has the mental capacity to make that decision. Or the other type is irrevocable trusts, which means those trusts cannot be changed. I won't get into all the details why we want one over the other, but it's just more advanced estate planning concepts for irrevocable trusts. Most of the people that I work with are going to use revocable living trusts while they're living for a trust. Now, when John dies, he's going to have a whole set of rules on what happens to those assets upon his passing. How is he going to provide for Jane, his spouse, if she survives him? We can make that very open and have liberal, definitions or whatever, where she can pretty much do whatever she wants to with those assets, or we can make those really conservative, where those assets are restricted in some way. So it just depends on the situation, family situation, assets, estate tax situation, how we set that up. And my main concept here is, we can make this trust revocable or irrevocable during Jane's lifetime. And then finally, when Jane passes away, we're going to do phase 3, which is now how do we distribute the remaining assets after Jane and John have both passed away to the kids, or whoever they want to give it to. So here we're giving everything to Tom and Sally outright, or we could set up trusts for them too. So as Nicole talks about some of the more details, you can kind of think about this and kind of see where she, all those different phases that she's talking about there. Okay, I think that's it for me. That's plenty for me. I'll turn it over to Nicole and take it away.
And also, before I get started, I wanted to let you know, somebody left a pair of red reading glasses up here if you want to grab them. They're pretty cute. Okay. Thank you, Chad, for that great setup. I'm going to talk about a few different topics, more focused on designing the terms of your trust, trust administration, and selecting the trustee if you do set up a trust. During what Chad calls phase 1 of the trust, that's while you, the grantor, are still alive. And typically you would serve as your own grantor. Sometimes husband and wife will serve together as co-trustees of each other's trusts. But you will want to have a successor trustee, and that would be the person who would act for you during your lifetime while you were unable to act for yourself, whether you were having a permanent incapacity or a temporary capacity. If you were hospitalized after having a stroke or something like that, then your successor trustee could just step in and take care of things and manage the trust for you. During phase 2, typically, with a married couple, all of the assets are held in trust for the surviving spouse, and we'll talk about some of the things that you can do with that, but that's typically just for the surviving spouse. And then at the death of the second spouse, it's divided up typically for the children, often in equal shares, and as Chad mentioned, you can have their shares either outright or in trust. So I'll talk about some of the factors that you might think about as you decide how to craft your trust for your family members. And I also want to note that these trust provisions can come into play either through a will-based plan or a trust-based plan. So you can have a will at the end of, maybe you can have a trust at the end of the probate process. So your assets that are held in your own name would flow through probate, and then they would fund the trust for your family members. When it comes to both children and spouses, you'll want to think about how you want distributions to be made for the support of your loved ones. So you can be very narrow about it, and you see this really more with kids or grandchildren, and say, you know what, only for health and education. Like you're very focused on what kind of support you want to provide. Or you can do what we call standard provisions, and that's called the HEMS standard: health, education, maintenance, and support. And that's that covers a very broad range of territory. Or you can have a broader standard and put in a little bit more verbiage and say, I want the trustee to be very liberal, or I want to make sure that this includes travel or study abroad. Be really specific about how you would like your family to be supported in your absence. Another thing you can think about is whether for your children or grandchildren, you would like the funds to remain in trust for their entire lifetime, or if you would like distributions to be made, outright distributions of the trust principal at certain stages. So a common plan that people have is they leave it in trust for their kids, but it goes outright in equal tranches at ages 25, 30, and 35, or 30, 35, and 40, whatever makes sense for your family. Or you could also grant them a right of withdrawal, which means that at certain ages or at certain time periods, maybe when they hit age 40 or 5 years after your death, they have the right to withdraw all or a portion of the assets. But there is a tax consequence to that. For any withdrawal right that a person has, that is treated as taxable to them. That becomes a grantor trust with respect to them. You might want to include special provisions for larger type purchases so that your trustee understands you're okay with a large distribution to put down a down payment on your child's new home or something like that, or for them to start a business or buy into a business. So that's very helpful direction to the trustee when they're making when a large distribution is requested. You can also put in there a requirement or a provision that allows the trustee to keep a residence for your spouse. So maybe you're still living in the house you've been living in for a long time, but your spouse decides, it's too much house, they want a condo, they want to move closer to the kids, then you can put a provision in there that says, always, you can sell the house and buy the house or condo that my surviving spouse wants to have, and maybe keep that as an asset of the trust. One thing people like to do sometimes is name the beneficiary of the trust as a trustee or as a co-trustee. You can, what I see that happening a lot with kids is maybe the parents feel they're not quite ready to serve as a trustee yet, so when they hit a certain age, maybe 25 or 30, they can step in as co-trustee, either with a family member or a bank, and then they'll have the opportunity to learn how to manage the money and how to become good stewards of the legacy that you and your spouse have created for them. Slide, thanks. Another common technique is families and estate planning attorneys will create what's called a pot trust, typically when you have younger children. And people like to do that because it more accurately reflects the situation if both you and your spouse were still alive. So all of the funds would be held in a trust until your youngest child hits a certain age. Typically that's age 22 or 23, or when they've all gotten through college or something like that. And then at that point, you divide it up into equal shares for the kids. And you can either set up the trust for them, as we've talked about, or you can have it go to them outright. Some other things that people take into account when they're drafting trusts is they put in kind of incentive provisions. They want to motivate certain behavior, or they want to use the money to help pass along family values. So whether it's making sure that you cover graduate school if that's important for you. You don't want the trustee to say, oh, it just says education, we got them through college, that's it. You might want to make sure they can go to med school or get their PhD in something. Sometimes you see people put in that they're worried that their children are going to become dependent on the trust funds, so they link their distributions to their W-2 income. And they say, okay, the trust will distribute 50% of your earned income. So show the trustee your W-2 at the end of the year, and they'll write you a check. But that can have an unintended consequence for families where one of your children is staying home and raising their own children, and then they don't get to benefit from the trust. So the document, you can put in there that even if they're not working, if they're contributing to society, they're working for a nonprofit, making a lower salary, or staying home raising children, that they can still have the opportunity to get additional distributions from the trust. Depending on what is going on with your family, what people's jobs are, what their marital situations are, you might want to leave things in a trust rather than outright, because that gives them some protection from spousal claims and creditor claims. So those are all things to think about when you're talking with your attorney about whether to leave things in trust or outright to your kids. And you can also consider your desire to preserve assets in the trust for grandchildren or other beneficiaries, nieces and nephews, whether you want to set something up for them right away, right at the time that you pass, or if you want to make sure there's something there for the grandchildren after your kids have passed away. When you're thinking about choosing a trustee, there's a lot that goes into that decision, and there's no right answer for anyone. What I would like to do today is just give you some ideas to think about so that when you do go in and talk to your estate planning attorney, you're kind of a little ways down the path already. You've thought about who you might rule in or out. So the candidates for that role would include family members, of course, friends, and corporate trustees. So you can have a bank serve as trustee or executor for you. You can serve either on their own or with a family member. So as you think about what goes into that decision, there are a lot of factors, including who has the expertise to do it, who's got the time to handle all of these tasks, and who has the personality to do it. Like, is it somebody who's detail-oriented and is going to go through the checklist of things that need to be done? How do they get along with the rest of your family? Lots of factors to consider. On this slide called selecting a trustee. Oh, yeah, please.
I didn't go over the trustees, but on your slide, the big slide, the phase 3 slide, 3-phase slide, we have trustees up here in the corner. And so these are the trustees like John would have chosen. So John is the trustee of his trust while he's living. While he's able to manage it, the trustee can always manage that. But then when John passes away or upon him becoming mentally incapacitated, he has named Jane to be the successor trustee. So she is managing the assets. And then he's named Tom as trustee if Jane couldn't do it. So in phase 3, after Jane passes, Tom would be the trustee. And the trustee is basically the manager of the trust. And like Nicole says, they're the ones making decisions on distributions and that sort of thing. And then finally, they've named the bank as the final successor trustee. Notice that Sally wasn't named as a successor trustee. And just like Nicole was saying, well, maybe this is because she just doesn't have the aptitude for it. Maybe she lives in California. Maybe she's an alcoholic. I mean, who knows? But there's reasons why you may or not want them in there. So, I don't know. Who knows? Who knows? But those are the things that we always think about when we're trying to name successor trustees. And as Nicole's going to say, there are lots of duties when it comes to being a trustee that maybe your family member might not be up for doing or may need some help from professional trustees on. So I just wanted to kind of show that where I had it in the phase 3 slide.
Yeah, that frames it up perfectly. Thank you. So going back to Chad's 3 phases, during phase 1, while you're still alive but unable to serve, your trustee will just be managing things for you, handling your investments, making sure that your bills get paid, taking care of all of those kinds of things. Then when you die, your trustee will have a role that's very similar to the role of the executor if you have a will-based estate plan. So no matter whether you have a will or a trust, there are still certain things that have to be done. That person will need to identify, collect, secure, and get a value on all of your assets. They'll need to think about how to manage or invest the assets that you have. They may need to open probate for you, even if you have a trust. They need to figure out what your debts were and what expenses of administration you have. There may be tax elections that need to be made. There will be federal and state tax returns that need to be filed, both personal, your final 1040, as well as fiduciary tax returns. So your estate or your trust has to file a 1041 every year while it's in existence. You'll need to prepare accountings and reports for the beneficiaries and for the court if you're doing probate. And you need to provide for accurate and timely distributions to the beneficiaries. So again, that's probate or non-probate as part of the post-mortem settlement of your affairs. And then during phase 2 and phase 3 of the trust, when the trust is set up for your spouse in phase 2, for your descendants in phase 3, all of that other stuff has happened, everything is settled out, money's in the right bucket, and the trustee's responsibility shifts to managing the assets, so making prudent investments under the terms of the document, taking into account and balancing the needs of both the current beneficiaries and the remainder beneficiaries. And the trustee is also responsible for making distributions to the beneficiaries. So sometimes the trust will provide that the beneficiary is to receive all income. So that's not its discretionary distribution. It's mandatory. You just need to make sure that the income is paid. Or there might be a unit trust provision that says, hey, pay 8% of this to my wife every year. Or it might just say principal is discretionary for health, education, maintenance, and support. In which case the trustee has to decide, okay, what is the appropriate amount for those things for the spouse or for the children. And there are often provisions as to whether the trustee needs to look to the beneficiary's outside resources, if there's any limitation on funds that can be distributed from the trust. Typically, the distributions are pretty broad for a spouse and maybe sometimes narrower for the children.
I was going to ask, so our panel, how many times, all the trusts that you see, what do you think the percentage is where it's just we call it the HEMS, like Nicole said, health, education, maintenance, and support. So any bank trustee is going to know what that standard is. It's basically kind of making sure that that person has living expenses paid for. How many times do you see the HEMS standard versus how many times do you see like those incentives that you talked about? Like we want to make sure they're gainfully employed and a productive member of society before they get anything.
Most of them are a HEMS standard or a little bit of a broader standard. Those more specific ones I have tended to see in families with a lot of generational wealth, and they're wanting to make sure that they don't have little bratty trust fund babies running around not contributing to society. But for most people, that's kind of beyond the scope of what they need. But it is, maybe some of you are in that category and you want to know what to do.
You have to be careful when you add standards into your documents because somebody has to interpret those, maybe many years after you've passed. So the easiest way, if you want to do the staggered distribution that Nicole's been talking about, that's the easiest way. Make some distributions over time, maybe a quarter at 25, a half at 30, and so on.
Yeah, I would say the vast majority go with the HEMS standard to make sure that their beneficiaries, their kids, their health, education, maintenance, and support will be taken care of. So every once in a while, there'll be some incentives, but most of the time it's HEMS.
Yeah.
Okay.
But there are people have all sorts of wacky stuff in the documents. It's interesting to see what people come up with. That's a broad array of duties and responsibilities when you're thinking about who's going to be your trustee. So some of the things I encourage people to think about when they're choosing their trustee include family harmony, using co-trustees, and whether it might make sense to partner with a bank or other professional trustee to help you with those things. So especially if you're in a blended family situation, it might be uncomfortable perhaps to have your child be the trustee for their stepmother. That can be a little uncomfortable. Or having a sibling being a trustee for another sibling. Or, people typically name their children in order of age. I don't know about the rest of you, but kids don't always like that. I'm the oldest of 5. I always got named first, and my siblings were all bitter. Make all the decisions, she's so bossy. And you might not want this. The other thing I would caution you about is if your kids do not get along now, they're not going to get along any better when they're co-trustees. So if your kids, and it may be your fantasy that after you die, they're going to start getting along great, but that is not going to happen while they're trying to figure out what to do with your money and set up a trust and do whatever it is that needs to be done. So in those instances, it's kind of easier to pick neither of them. Pick the third child, pick a bank, maybe your brother or sister could do it for you. But just a lot goes into that decision. But I would also say, please don't get hung up on who's going to be the trustee. Don't let that make you not go to your attorney to get it done. Like I know plenty of people who, when their kids were younger, never got around to getting their wills because they couldn't agree on who was going to be the guardian for their kids. So, the older person's version of that is, we don't know who's going to be the trustee. Just at least get the process started, and you can start noodling through some of these decisions as you go through it.
So this may be a plug for corporate fiduciaries, but sometimes the plan really dictates who you should select for a trustee. For example, I'm currently working through a trust that held farmland until one of the grandkids passed away, and that grandkid didn't die until he was like 102. I think the trustee is 125. I'm not kidding. And he lives in Hawaii, and he's basing all his decisions on conversations he had with the decedent 45 years ago. So it's been rough. So keep in mind, if you're gonna have a plan that goes on for a long time, you gotta keep that in mind when you're selecting your trustee.
Yeah, that's a great point.
Yeah, I would just add to that too, if you go to the diagram too, a lot of times if people really want to have their individuals, family members as successors, I always encourage to name a bank as kind of the final successor just in case. Those people have passed away, they moved, they don't want to do it. Then you've got somebody in place that's a professional that knows what they're doing to basically take over, and nobody has to make any decisions about that. So that's kind of why I showed that bank in there as the last one too.
Yeah. You know, another thing too is, you know, you may name an individual as trustee. They don't have to do all the investments themselves. They can hire someone else to do the investments. Their responsibility is to choose someone who's going to do a good job managing the money. And, you know, you can also hire, you know, if you have an individual trustee, you can hire a bank kind of as agent for trustee, and they'll take care of a lot of those things for you without quite stepping in as a full-on trustee. The next thing we're going to talk about is, on the next slide, is wills versus trusts. So Chad has talked about what is a will-based plan, what is a trust-based plan. I'm going to talk a little bit more about how you decide which way you want to go, what makes the most sense for you. And I will start off by saying that you can achieve the exact same dispositive provisions. Everything I've already talked about, you can do with a will or a trust. You can achieve the same tax consequences. You can do the same tax planning with a will or a trust. What I recommend to our clients when we're talking to people now, people who are about to retire or past retirement age, I encourage them to do a revocable trust and have a trust-based plan for the purposes of incapacity planning. So even though if you have a trust, you'll still have a will. It's called a pour-over will to pick up any stray probate assets you may have forgotten about, some random checking account you opened somewhere to get a toaster, or they have to write on a CD. We'll still need to go through probate. But then everything is already in your trust, and your successor trustee can just step right in and take care of things. Of course, you'll have your power of attorney documents drafted as well, but I've worked at 3 different banks, and I'm going to tell you, they all accept powers of attorney, but it's a lot smoother to deal with people's assets if you're trustee than as attorney in fact, because the powers the forms vary from state to state. All these financial institutions have different ways of looking at them and reviewing them, and they feel they have a lot of liability if they do something under a document that they don't feel quite grants that power. Whereas if you have everything or as much of your assets as possible in a trust, then it's much easier for your trustee to just step in and act literally in your shoes. So to me, that's a very important factor. I don't know if you guys are nodding. That you know, I encourage people to do a trust. Yes, it's going to cost a smidge more when you're doing the planning, but not a lot. To me, that's being penny wise and pound foolish if you're trying to save a few $100 by not having a trust. It's going to pay for itself in the long run when your family members need to act for you. Some people want to avoid probate. As Chad mentioned, it is a court process. It is a public process, so nosy people could go pull the records and look stuff up. You may prefer to have more privacy than that. But some people don't care. There are costs associated with probate, you have probate fees and everything. But even if you, for your trust settlement, as we talked about earlier, all the same activities may need to occur, you're still going to be incurring fees. You're going to have an attorney helping you, whether you do probate or whether you're doing a trust-based postmortem plan. So that isn't that big of a deal. Sometimes you actually do want to open probate. So when you open probate, it starts a 6-month period in which anybody who's a creditor of your estate can file their claim. So you may be in a situation where you want to make sure those claims get cut off after 6 months. So you'll open probate to start that 6-month clock ticking. You may need to open probate if you have a power of appointment that you need to exercise. Maybe your spouse or one of your parents had you as a beneficiary in their trust and left you with the power to appoint the assets that remain in trust at your death. Some documents provide that gets done as part of the probate process. Additionally, you may, if you think your plan may be contested, you want to start the 6-month will and trust contest period as soon as possible. So those are some reasons for opening probate.
Those are all very good reasons for sure. I do a lot of probate administration in Bloomington, McLean County. It's very simple. State of Illinois, the probate proceedings are very straightforward. So it's nothing to be particularly scared about. But there are a couple of things that I've seen in my practice that would cause you to consider getting trust. One is if you own real estate in another state. A lot of our people here like to get away for the winter or so on. Probate proceedings in other states like Florida, Arizona, and California can be very complicated, can be very, very expensive, and you can solve that by having some trust here, entitling those assets into your trust, and then you'll avoid the probate in the other state. Another situation that is if you have a lot of beneficiaries. Some of my clients may be giving money to 20 grandchildren or great-grandchildren. But in the probate proceedings, that requires notices to all those folks a couple different times. And so if you're going to give money to a lot of beneficiaries, you should have a trust, and then the trustee does not have to follow the probate rules for notice and so on.
Yeah, great, that's a good point, thanks, John. I think that's the end of my presentation. Back over to you.
All right, I think then we're ready for John and the estate tax overview.
Thank you. So they gave you the boringest topic and now the scariest topic, estate tax planning. After you die, essentially there's 2 types of tax. There's estate income tax, and then there's estate transfer tax. And the income tax is just like the income tax you have now. You have to pay income tax on dividends, on interest, on rent, IRA distributions, and those kinds of things. Well, your estate is going to receive that kind of income after you pass away, and the state's going to have to make arrangements to pay the tax, the income tax on that. But there's this other thing called estate tax, which is a transfer tax. And that's a tax on the transfer of your wealth to someone else. And by definition, that's going to happen after you pass away. Your assets are going to be transferred to someone else. And that transfer is subject to tax. If you make the transfers during your lifetime, it's a gift tax. That's similar to the estate tax. But we're going to concentrate today on this transfer tax. Now, there is an Illinois estate tax and a federal estate tax. So we're going to look at both of those. And many people will ask me, well, what is subject to tax? What is subject to this transfer tax? And basically, the general rule is everything that you have an ownership interest in at the time of your death is subject to tax at the fair market value at the time of your death. So if you have an ownership interest in it, in an asset, it's going to be subject to this transfer tax. A lot of people will say, well, Pratt, life insurance is not subject to tax. Well, life insurance is generally not subject to income tax, but it is subject to transfer tax. So if you have an ownership interest in a life insurance policy and it's based on your life, then the death benefit is going to be included in your estate for transfer tax purposes. If the decedent owns joint assets with a spouse or with other parties, that's subject to tax too. Whatever interest the decedent has in the joint asset. Now, that being said, there is this thing called the unlimited marital deduction. That's a really cool concept that you can give an unlimited amount to your spouse during your lifetime, free of any tax, and you can give an unlimited amount to your spouse after you die, free of tax. So if you have a joint account or joint asset with your spouse and you die, it's not going to be subject to tax because of the unlimited marital deduction. So the next thing people want to know, well, how much is the tax? Well, in Illinois, I think we wrote up there that Illinois, the threshold amount is $4 million. And so if you have anything over $4 million, if your estate is valued at more than $4 million, then you're going to have tax in your estate. It's serious. If you're over $4 million, the Illinois estate tax is very serious. A lot of people want to know the rate. The rates are relatively small. In fact, the top end of the rate is 16%. That doesn't sound too bad. However, that's not the way Illinois doesn't really tax the increment. And that's a hard concept to get through, but I'm just going to give you an example. If you pass away with $5 million, let's say, and remember, everything you own is subject to this tax. If you pass away with $5 million, the increment's only $1 million, right? That doesn't sound too bad. But the tax on $1 million in Illinois is $286,000. And because Illinois doesn't really just tax the increment, that increment would be 28.6%, but that's not how the tax works. So if you're over $4 million, you need to be careful about this Illinois estate tax. The other tax that we have, of course, is the federal tax. And put up here, the federal tax, as you guys know, the unified credit amount has gone up and up over the years, and now it's at $12,060,000. And so you have to have $12 million to be subject to federal tax. Those tax rates are 18% at the low end and 40% at the high end. So if you are in that position, the tax is serious. Can we reduce the estate tax? Well, yes, we can definitely do some things to reduce estate tax. The unlimited marital deduction we talked about earlier, that's very, very important. We really don't want tax when the first spouse dies. We really don't want our plans to create any tax when that first spouse dies. Example of that is if the first spouse died maybe 10 or 15 years ago, and left everything to the surviving spouse, or maybe it may not be a taxable estate anymore because of the way the laws have changed. So you certainly don't want to pay tax then. Just a little words of wisdom, I guess, out there. If you have one of these old plans that have credit children trust in them or AB trust in them that are relatively old, you might want to get those looked at because they might actually create Illinois estate tax inadvertently when the first spouse dies. Because it used to be that the unified credit amount and the Illinois state threshold amount were the same number, and they're not anymore. So all of a sudden you have an Illinois state tax inadvertently. So take a look at those tax plans if they were done quite a while ago. You can make gifts during your lifetime called annual exclusionary gifts. Right now, the amount you can give is $16,000, and if you're married, then you can give $32,000 a year. And it's per person per year. So if you have a lot of people to make gifts to, you can really reduce your estate in a hurry using annual exclusionary gifts. And those are free, that's free of tax, free of any gift tax. A lot of people like to use the annual exclusionary gift amount to get assets that are growth assets that are appreciating in value, and if you can get those out of your estate, then they're not going to continue to grow inside your estate and create future estate tax problems. Some people like to give income-producing assets away because then they don't have to pay the income tax on. They let their kids or whoever pay the income tax. Another way of sort of reducing your estate tax burden is with gifts to charities. The transfer to charity is not subject to estate tax. So if you're straddling that $4 million number, you might want to make gifts to get you under that $4 million, and then you don't have to pay Illinois estate tax. If you're going to give amounts to charities, you should really think about your IRAs or 401ks and your other tax-deferred retirement accounts. You should really think about using those accounts to make your gifts to charities. Because what happens on these tax-deferred accounts is when you give those to your beneficiaries after you pass away, they're going to have to pay income tax when they withdraw, right? Just like you did, they're going to have to, because nobody's ever paid income tax on them. But if you give that to a charity, the charity doesn't have to pay income tax on it. And it's not subject to transfer tax. So you sort of avoided two types of tax by using beneficiary designation. So you can essentially, you can give after-tax dollars to children or other beneficiaries, and these tax-deferred dollars to the charities, and you can increase the amount, essentially increase the amount you're effectively giving to other people when you pass away. One last tax planning device is the old credit shelter trust, which is something that I've been doing for 30 plus years. This only works with husband and wife, and I think I'll just use myself as an example, although I wish I had $6 million, but I'm going to use that anyway. Suppose that I had $6 million at the time of my death, and so what I would do is I would create a trust either in my will or using a revocable trust that we've been talking about. That's called a credit shelter trust, and it would hold $4 million in it. And that's the threshold amount, right, for the state of Illinois. So that's why I picked the $4 million. So that's going to hold $4 million in this trust after I die. And then the other $2 million is going to go to my lovely wife, Paula. All right? So that $2 million that goes to Paula is not subject to tax because of the unlimited marital deduction. The $4 million that I put in the credit shelter trust is not subject to tax because it's below the threshold amount. So then the $4 million, when Paula dies, that $4 million that's in my credit shelter trust will go to Robbie, free of any federal estate tax in my estate and free of any federal estate tax in Paula's estate. So effectively, we could give up to $8 million to Robbie. Now the really cool thing about the credit without tax, so we could give $8 million no tax. But the cool thing about these credit shelter trusts is that we can design them so this $4 million after I die, Paula can have the income off of that trust during her lifetime. She gets the income. And she can encroach upon the principal basically if she ran out of money. If she ran out of money, she could get this $4 million. So it's really no harm, no foul. You create this credit shelter trust, and then if Paula doesn't need it, she can let it grow, she can take the income, and it'll all pass to Robbie free of tax. So that's our tax planning strategies for the day.
Very good. So now we are kind of in the home stretch of our presentation. Now we get to the words of wisdom. And I don't know who would want to start, or Nicole, do you have any words of wisdom you'd like to share?
I do, but I know they're going to come across more as pet peeves than so yeah, I do have a few thoughts. One thing that, if you're thinking about getting your documents redone, and you're getting a new will, and you decide you're going to a trust-based plan, I would really strongly encourage you to do new powers of attorney as well. Even if you have old ones from your old plan, the statute changes over time, and your situation changes over time. So as you get older, as your estate gets larger and more complicated, you may wish to add some broader provisions for your attorney in fact. What I see happening and what makes me sad is when people have these old and narrow powers of attorney documents, but they're in a situation now where they need to, but they don't have capacity, and no one can help them do some additional estate planning to reduce their tax burden or whatever. So if you can give your attorney, in fact, the authority to create a trust for you, change beneficiary designations on things, I would just encourage you to think very carefully about building in some flexibility for your spouse or your children in case some planning needs to be done that you're not able to do for yourselves. And you can really save a lot of money by being thoughtful in that way. So that's one thing. Another is, we talked a lot about all different ways that you can structure your plan. You can put in all these incentive provisions and everything. I would encourage you to try not to be a control freak. Try not to overthink it. You'll spend more for the custom drafting, and you'll make it much more difficult for whoever's administering that for you in the future. You may be putting forth your plan and how you want things, but you could be inadvertently tying the hands of your family and your trustee and end up frustrating your own plan, or making them spend more money by going to court to get it interpreted to make it work smoothly. I have a bunch more, but I'm going to just offer a couple. We talked a lot about how your assets are titled. Just really encourage you when you're working with your attorney to make sure you think of every single asset that you have and title it in such a way that your whole plan is coordinated and consistent, so that an errant mistitling doesn't end up frustrating your entire plan. And my last thing is, again, on the penny wise, pound foolish. I would really encourage you to go to an attorney to get your documents drafted rather than go to 10-speed press or whatever and download something off the internet that may or may not be really as perfectly suited to your needs as it should be. I think you're really much better off talking to an attorney and getting a plan that's, even if it's very kind of plain vanilla and very straightforward, it's still specifically tailored to your needs and the laws of the state in which you live. And if you do anything on your own, please don't just scratch it out or handwrite in somebody's name or different dollar amounts, because that makes it very difficult for everyone. Thanks.
So obviously, over 37 years, I've seen quite a bit on the planning stage, but when you really see problems arise is after the fact, after a person has passed away. And the one thing that I wanted to bring up today is something that we see over and over and over again, and that is using joint tenancy accounts so you can solve a number of things. The reason why people use joint tenancy accounts, the number one reason is they want their kids to be able to write checks for them. Well, you can actually just have them on as an authorized check signer or a power of attorney. They do not have to be a joint tenant, but you might have to explain that to the teller who you're talking to. Another reason why people like to use joint tenancy accounts with their children is so that after they pass away, that child can pay all the expenses and then make a distribution of the rest. And that child's very responsible and so on. I like to say that my dad practiced law for over 50 years, and he had no joint accounts with any of his children, none. So the problem really is that if you make a child a joint owner, you're actually giving that child the money now. And so if you know, there's probably, in this room, there's probably not a lot of risk that your child's gonna take the money and run. There's probably not a lot of risk. But if the child has creditors, or if the child gets a divorce or something like that, then there's issues about your money. This was your money, and you only put it in joint tenancy because you wanted these opportunities, so to speak. There's better ways to plan it that way. But then now what I'm seeing over and over again now is, and they're not plans that I normally work on, it's something that's coming to my office later, is the joint owner of that child has a lot of money at the end. So the parent has left that child maybe $250,000 in a checking account. And the child doesn't need that much money to pay the expenses with. Now what's the child do now? The parent might, you know, the child is in a dilemma. And it's a lot of stress for that child. Do they make distributions to the other children, you know, the siblings? If they do that, that's a taxable event to the child, because the child can only give $16,000 a year to the siblings. Or did the parent really make the gift to the child that's on the account? I've had people in my office crying about this. It's a tough situation. So please avoid it. I mean, if you're really worried about avoiding probate, if that's what you're really worried about, get a trust.
All right, oh, keep that. My words of wisdom, I know we've thrown a lot of stuff at you guys. This is a lot of information. I think I like to just really simplify the decisions that you would have to make as part of the estate planning process. That's why I really think probate, knowing what kind of assets you have, and if they have beneficiary designations, really helps determine if things are going to avoid probate or not. And that also helps determine if you need a will-based plan or a trust-based plan. Once you decide, and once it's determined if you need a will or a trust-based plan, then we can, if it's a trust-based plan, then we can talk about all these things that we've talked about as far as who the trustees are, what kind of distributions will that trustee make to your spouse and to your kids, and get all of that taken care of. If you just need a will-based plan, a lot of that is pretty straightforward. So the other thing too is, yeah, the beneficiary designations, whenever we go through someone's assets, there's always beneficiaries that need to be updated. So that's something it's a simple concept, but I know it's just a lot out there that needs to be done a lot. If people just had their beneficiary designations updated and did nothing else, that would help immensely, no matter will or trust or whatever. So I guess those are my words of wisdom too. Okay, so then Q&A. I don't know, does anyone have any questions? I know there's some questions in advance, but we'll take questions from the audience right now. And Brett, we'll just make you a moderator.
So we are bumping up against 11:30, so we'll take a few questions. I know Chad, John, and Nicole will be around after the fact too, to take those questions. Just a couple comments real quickly. This is being recorded, and so this will be available on the Timer's website after the fact. So if you want to go through and review this is available on the website for you. While I'm walking around the room, just a quick comment. We are in the trust business, and so we do see a lot of these things that come up on a day-to-day basis. General comments on what your thoughts are around qualified assets and naming a trust as a beneficiary of qualified assets, and why, even with tax ramifications, you might want to look at something like that and look at pros and cons as I kind of walk around. If anyone wants to take that, or what's the best way to address that?
Any questions, any thoughts, John?
You talk about your IRAs and things like that. Yeah. Well, there's pros and cons, of course, associated with anything that you do like this, but a lot of times you really do need a fiduciary for your qualified assets because your beneficiaries are just not capable of receiving the money yet. Like my son just turned 20, and I walked around the block with him and I said, I'm going to leave this to you now, but don't blow it. But I just now did that, you know. I mean, before then, I had it in a trust. I had this IRA going to a trust. You gotta be careful, and there could be other recipients that are either disabled or special use trusts things like that. So the downside, of course, is that the tax is generally payable at the time of the distribution, generally speaking. I mean, there are ways you can get around that, but generally speaking, if your IRA goes to a corporate fiduciary in some manner, then you're going to have to pay the income. That distribution is going to happen at that time. You're going to have to pay the tax.
I will say on that question, so if you need to name a trust as a beneficiary of an IRA or whatever, that trust should be what's called a see-through trust, and it's a special type of trust. It's got special provisions in there so that the IRS doesn't see your trust as a beneficiary, but the beneficiary of that trust, so your children and so forth. So it needs to be set up correctly, and it's not just a general standard trust. So, yeah.
Thank you. Questions? Who we got first? I saw a hand over here first.
I like the idea of having the bank as a final successor, but do you name the bank or a person at the bank? You
We
name
did the bank.
institution.
Yeah.
I have a question about what you said about the tax ramifications. If you have a trust of the outright distribution versus the right of withdrawal, like yearly.
Oh, yeah. Can you hear me? Yeah.
Think so.
Okay. You guys in the back hear me too? So, if you have, if they have the outright distribution, they're taxed on that when they get it. So if they get a third of the money when they're 25, they will pay income tax on the distributions. But if you just give them the right to withdraw, they basically become the owner of that trust with respect to the amount over which they have a withdrawal right. So over that amount, they're treated as the owner.
So, I mean, does it fall under that 12 million and 4 million for, let's say at the end of someone's life, it's in a trust money, and if it's an outright distribution, then it falls under the 12 million and the 4 million, versus a yearly distribution would be fall under income tax.
Yeah. But if it's in the trust, still when they die and they have a right of withdrawal over it, then it counts towards their 12 million or 4 million for that time.
Yeah, the transfer happens at the time of death. So even if the distributions are staged over time, is that getting to the heart of your question?
Right, I'm trying to figure out if it would fall under the inheritance tax versus your yearly income tax.
It does fall under the inheritance tax.
Okay.
Even if you stagger the payments.
Oh, even if you stagger, okay, that's what I misunderstood. It made it sound like staggering it would fall under your yearly income tax versus the estate tax.
The key always is, we're talking about transfer tax, right?
Right.
Not income tax. But the key is, when did the gift happen? And when is the gift completed? And even though the recipient isn't going to receive the money until other years, the gift happened from the donor into the trust at the time of death.
Okay, all right, gotcha.
Good question.
If I have my will and trust made in Illinois, and then I change my state of residence, do I have to redo my will and trust?
Usually.
Yeah.
Yeah.
Most, I'm not going to answer any questions regarding Louisiana. But otherwise, there's reciprocity in most states. So most states are going to look at your documents, and if they were valid in Illinois at the time you did it, they're going to be valid in that state. That being said, though, there are a lot of things in states that are different, like community property states and so on. So I don't think it's an emergency, but at some point in time, if you move to another state, you need a checker. You need to have somebody look at your documents. POAs, the powers of attorney, you definitely want to have somebody look at those pretty quickly. Nicole is absolutely right. Everybody looks at those powers of attorney for property and sort of examine them under their own parameters. So you definitely want to have those up to date when you move to a different state.
let's take one more question, because again, we are at 11:30, so I don't know who has.
If you have a revocable individual trust during your life, I think I heard you say that successor trustee is only valid during that life of that person. Is that correct?
No, it is not.
Oh,
So
okay.
the successor trustee, well, it depends. I mean, you could put it like you could have somebody be the trustee while you're still alive, and they could continue as trustee after you die, or you could name someone else to step in after you die. Typically, it's the same person. It's usually the surviving spouse or one of the kids.
So when you die and you have a revocable trust, it becomes an irrevocable trust. Is that correct?
Yes, exactly.
And the successor trustee then becomes the trustee of the irrevocable trust?
Yes.
Thank you.
You're welcome.
Go ahead, sir. One more.
Real quick, you mentioned designating executors, trustees, and so forth. What about telling those people they are the executor, the trustee, and so forth, or designating their designated beneficiaries, for example?
Yeah.
What about informing them of their role or their responsibilities?
I don't know what you guys think. I think that's a great idea to let people know. And also, maybe, not all families talk about all of their financial situations with their children, but it can be helpful to let them know your general plan and maybe why you chose to leave things in trust versus outright. Or if you're leaving one child share in trust and everyone else gets it outright, making sure they understand that. We see a lot of unhappy people in that situation. But yeah, letting people know that they're named is very helpful for them to know what's coming their way. To let you know, please don't put my name in there.
I agree with that. I mean, the general rule is the more people know about what your plan is in your circle, the better. However, that's just a general rule. I have some clients whose kids would wear them out, but they knew what the plan was. Every time they got together for dinner or whatever. And it's really not their business. So in those situations, I tell my clients, it's not your kid's business. This is your business. And you don't have to tell them.
I agree. I think every family dynamic is different, but in general, it's best that the executors, especially the first successors, would know that they're named and that they would know where your will and trust are, so that they have access to those.
The other thing you can do is draw up kind of a letter of wishes, sort of explaining some of that. If you don't have a chance to tell them, or you don't want to tell them while you're still alive, you can just basically leave a note saying, this is what I did.
Your kids definitely need, or whoever your agents are on those powers of attorney, they need to know that you've done them, that they're named, and where they are, where the documents are. Definitely.
So, Chad, the last question for you here, and I'll give it over to Kathy to close this out. You spent all this time, all this effort, building and structuring an estate plan. What's a common cadence to review that as far as laws are concerned, and what's the best course of action in that regard as far as if you're going to spend a lot of time?
Right. So once you get your documents done and updated, a lot of people didn't just kind of forget about them and just don't want to even think about it for a while. But I would say, a good idea is to just think about your estate once a year, whether you've got new bank accounts, life insurance, new house, those types of things can all maybe need some tweaking or at least updated beneficiaries for those things. What I see in my practice is, after 3 to 5 years, I might start seeing a client again that needs just to make a little tweak to their will, or something's happened where we need to make a major update. So I would say 3 to 5 years is probably a good estimate as far as getting things updated or reviewed.
I would just add, if there's a life event, if anything happens to anybody that's named in your documents, whether they're a fiduciary like an executor or a trustee, or whether they're a beneficiary, anything happens to any of those folks, you should review it. Maybe there's nothing that needs to be done, but it should be reviewed then.
Yeah. Or at certain stages are kind of obvious, like when you're getting ready to retire, or if you have a business that you're selling, or once your kids are all settled and established, and you've got grandkids, and you kind of see how are they good with money? Do they need their money in a trust? Whatever it's going to be, you'll have a better idea as they get older. But also maybe as your folks die, they might have shared their plan with you. Now
thank you very much. There was a lot of good information here. And thank you all for coming today. Our next meeting is in November, and it's on a Thursday, and I'm not sure if I'm making this up, but it's November 10th or November 11th. It's an end of the year financial review. And don't forget to check the Gold Timers website for all the information that I was talking about earlier. And I'll see you next time. Thank you.